Hello and welcome. I'm going to read a few court documents with you. It's in the Massachusetts versus Karen Reed case. These two court documents were submitted today, March 21, 2025. Thank you for being here. It reads Commonwealth versus Karen Reed. It's stamped March 21, 2025. Commonwealth's motion to compel communications between the defendant and attorney Yannetti stored within the defendant's cell phone data. The Commonwealth seeks all texts, emails, or written communications between the defendant, Karen Reed, and attorney David Yannetti, restricted to those communications that occurred between January 29, 2022, and February 2nd, 2022. And there's a footnote. I will read it in a moment. The privilege holder, Karen Reed, has waived her attorney-client privilege with attorney Yannetti relative to any statements about her collision with John O'Keefe during the time of January 29, 2022 through February 2nd, 2022. And guys, notice how the prosecution keeps referring to what happened to John O'Keefe, to what they say happened to John O'Keefe with certainty. They say it like it really happened. Her collision with John O'Keefe, as if it really happened. They don't use the word alleged. They don't use the word purported. They say it like it really happened. It's crazy, right? How the prosecution, when it comes to something that's really scientific, they'll say alleged or purported, even though it's really scientific. But when it's something unscientific, like this idea that Karen Reed struck John O'Keefe with her SUV, it's extremely unscientific. The prosecution states it like it's a fact. Continuing. The defendant voluntarily and intentionally disclosed the existence of these communications and her initial thoughts about her culpability for causing the death of John O'Keefe during various public interviews. The communication confirmed by the defendant to exist are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them. There's another footnote. Let's read footnote number 1. Pursuant to a search warrant, the Commonwealth received the contents of the defendant's cell phone because of an observed attorney-client communication. The phone data was provided with the assent of the defense to the Attorney General's office, and a court-ordered taint team protocol was implemented. The Commonwealth received the defendant's phone data with any privileged communications excised. Given the defendant's public waiver of the attorney-client privilege as it pertains to the defendant's conversations with attorney Yannetti on January 29, 2022, and the following 3 days, the Commonwealth is entitled to the communications between the defendant and attorney Yannetti for this waived narrow period of time. I disagree, guys. I disagree. Because Karen Reed shared some of her communications with David Yannetti during those 3 days, the Commonwealth wants all of the communication Karen Reed had with David Yannetti for the entirety of those 3 days, January 29 through February 2nd. That's unheard of. They're not entitled to all of the communication. It's just because she talks about some of the communication doesn't mean she's waiving her right to the attorney-client privilege for all of the communication that occurred within those 3 days. That's a stretch, it's a whole stretch, like, no way. You gotta do better than that. Continuing. In support of this motion, the Commonwealth acknowledges and respects that the attorney-client privilege protects privileged communications between a client and his or her attorney. Massachusetts Rules of Evidence 523 provides waiver of privilege. And I don't know why they chose to provide the entirety of the waiver of privilege as it's stated in the Rules of Evidence. But I'm not going to read it. I'll leave the link in the description below if you'd like to read it all. It's just silly. Like, they need to be citing a section of it per, like, for the argument they're making, but they cite the entirety of the waiver of privilege. And again, it doesn't matter because she's not waiving all of her communication. She's not waiving the right of all her communication by discussing some of her communication. So this part voluntarily discloses or consents to disclosure of any significant part of the privileged matter or introduces privileged communications as an element of a claim or defense. It doesn't say that when an accused discloses some of the communication, they have waived their attorney client privilege to all of the communication. Okay, continuing, guys. We're going to read footnote number 2. It pertains to this sentence. The communications confirmed by the defendant to exist are no longer privileged or confidential because the defendant chose to widely and publicly disseminate them. And there is a footnote number 2, to ensure that only the communications that were waived are provided. The Commonwealth requests that this honorable court review in camera all text messages and written communications stored in the defendant's phone data for the time between January 29, 2022 and February 2nd, 2022, to ensure that only the communications that were waived are provided. The prosecution is asking Judge Bev to review in camera all text messages and written communications stored in Karen Reed's phone data. And guys, for those of you who don't know, in camera, when you're referring to a court proceedings, in camera has nothing to do with what we understand as camera, like a photographic camera or a video camera. When discussing court proceedings, in camera means in the judge's private quarters, also referred to as chambers. Like behind the courtroom, usually the judge has a private room, and that room is usually referred to as chambers, the judge's chambers. So the prosecution in this motion so far, they are asking Judge Bev to take the cell phone data from Karen Reed's cell phone from January 29, 2022 through February 2nd, 2022, and they're asking Judge Bev to review all of that communication between those 3 days in her chambers. Like, it's unheard of. Like it's as if this motion is to benefit the prosecution to again get Karen Reed in another gotcha moment, another gotcha thing where they can like, oh, we found this, oh, right? But it's also of benefit to Judge Bev. It's like giving Judge Bev agency to go over Karen Reed's cell phone data, the communications for the entirety of 3 whole days between January 29 and February 2nd. It's unheard of, guys. It's improper. They're supposed to cite like a particular argument or multiple arguments, uh, and they're supposed to like cite the specific communication their arguments apply to, and vice versa. It's not Judge Bev's job to go through the entirety of 3 days of communication between Karen Reed and David Unetti. It's the prosecution's job to pick whatever communication they say is concerning or inculpatory, and then refer to that particular communication and give that particular communication to Judge Bev. It's not Judge Bev's job to look over all the communication that occurred within those 3 days and say, yeah, you're right, prosecution. Yeah, yeah, I see this one and I see that one. And I say, No, it's the prosecution's job to present their case, to present their arguments, and to make it easy on Judge Bev, to make it easy on the judge. Like, if she grants it, guys, uh, I'm saying, like, the legal argument is not there anyway. I don't see her being able to grant this anyway. But if she grants it, we will all know that this motion is not just for the prosecution, it's also for Judge Bev. It's like Judge Bev making her own court order that says, I'm going to get into Karen Reed's cell phone data and I'm going to go over everything she said to David Unetti during those first 3 days that John O'Keefe was murdered. So I'm just saying, guys, if she grants this motion, it will prove that this motion was for her and the prosecution. It will prove that they are working together. That yes, they are in cahoots, because no judge in their right mind would grant this motion. No judge in their right mind will be like, yeah, I got time to go over 3 days, 3 whole days of communications. Yeah, I got time to do that. No, it's the prosecution's job to pick whatever specific communication they're referring to and to provide that specific communication to Judge Bev. And it's not supposed to be in the entirety of 3 days. It's not supposed to be days and days of communication. They're supposed to pick which segment of the communication and then hand it over to Judge Bev. So again, guys, if she grants it, it will be unheard of. Every judge in this country will be looking at her like, what the hell are you doing with the defendant's cell phone data? Just saying. Continuing. In this case, the privilege holder, the defendant, has clearly and intentionally waived her attorney-client privilege regarding specific conversations she had with attorney Unetti regarding the collision between her vehicle and John O'Keefe. Again, guys, look at how they don't use the word alleged or purported. They state the collision between her vehicle and John O'Keefe as if it really happened. Guys, there are no verdicts here. Because of Judge Bev, there are no verdicts here, right? Because of Judge Bev, there are verdicts, but because they weren't announced in open court, they don't matter, right? So you can't do that as the prosecution. You got to pick one. Either there were no verdicts or there were. And according to the prosecution and to Judge Bev, there were no verdicts because the verdicts were not announced in open court. We all know, those of us paying attention to this case, we all know that there were verdicts. But according to Judge Bev and the prosecution, those verdicts don't matter. So you got to pick one. You can't keep saying, you can't keep referring to it as a fact. The collision between her vehicle and John O'Keefe, her collision with John O'Keefe. You can't keep referring to it as if it really happened when you didn't allow the verdicts to come through. When this case is not solved, this case is not closed, right? The prosecution has not proven their case yet, but they feel like they have the license to refer to it as if it really happened. And guys, it's all image. It's all strategic. It's all on purpose. And as I said over and over again, Hank Brennan thinks that if he repeats a lie enough, some people will believe it. Continuing, for example, in the defendant's recorded interview with Gretchen Valls on June 20th, 2023, he cites the transcript. The defendant concedes, quote, question, you never said, did I hit him? I hit him. Answer, I said, did I? Could I? Did I hit him? And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there's capability there. And I thought, all right, maybe this is what? Maybe I said to my mother, just to go forward a second, they were asking me, What was it like? Did they come out? What was the house like? End quote. Attorney Yannetti, Attorney Jackson, and Attorney Little were in attendance along with the defendant and Miss Voss. So, guys, it's another reason for this motion to cherry pick Karen Reed's statements from these interviews and not provide the context surrounding her statements, to omit the context surrounding her statements and just pick the statements she says in these interviews that appear inculpatory to the prosecution. Uh, and like pathetically, like uh, it's excruciating. Like without the context, it doesn't even look inculpatory. It's all broken language. Like guys, look at it. It's broken language. Did I hit him? Could I? Did I? Uh, and then, when I talked to David, now this is later, Karen, if you incapacitated him in any way, uh, I said to my mother, just to go forward a second, they were like, guys, it's broken language. So not only are they citing like a shitty segment of the interview, they think it's inculpatory. They think it's like, oh, this is Karen admitting to something. Oh, look at this suspicious like, no, it's fucking broken language anyway. Like, how are you gonna cite that statement that's so broken and it has so many like, again, guys, look, like, how are we supposed to understand any of this? And it's like it's so weak is what it is. It's pathetic. The prosecution is like, oh, incapacitated. Oh, we got it there. Oh, capability there. Holy shit, she's really telling on herself. Like, no, she's not. She's not telling on herself. Where's the context? And where's the whole sentence? Where is there an entire sentence? I can't even understand what she's saying. Continuing. Second, in a Vanity Fair article entitled, quote, Karen Reed Tells Her Story, Part 1, A Murder Trial in Massachusetts, end quote, with a caption, quote, as Karen Reed's second murder trial looms, she's ready to talk about what she says really happens, end quote, published on October 29, 2024. The defendant, who according to the publication was, quote, notably aware that anything she said could be used against her, end quote, volunteered a, quote, rumor, end quote, that alleged representations made by the Massachusetts State Police that there is text message between her and counsel that implicates herself is a, quote, provable lie, end quote. You guys see that? Look at how shitty that second paragraph is. Like, it's broken. It's more broken language. Look at it. Holy crap. Look at it. Like, what the hell are we supposed to ascertain from this? It's, again, without context, and they are highlighting words, they're highlighting alleged statements that were made. Notably aware that anything she said could be used against her. Ooh, a rumor, a provable lie. Like, what what the hell? Look at this paragraph. Broken language, no context. Look at this paragraph. Broken language, no context. Like, if you read this paragraph, you don't know what the hell is going on. You don't know what the hell she's really saying. And if you read this paragraph, same thing. You don't know what the hell is going on. Like, we don't know what the hell she's really saying. Like, where's the argument? Where's the legal argument? Where's the actual citation? And where's the context? Disgusting, like how far they're willing to go with like. Okay, continuing. Third in the third in the now airing 5-part docuseries on Investigation Discovery and HBO Max titled, quote, A Body in the Snow, The Trial of Karen Reed, end quote. The defendant professes, quote, and then when I hired David Yannetti, I asked him those questions the night of January 29th. Like David, what if, I don't know, what if I ran his foot over, or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability. So that's how I thought about things for about 3 days. Well, where do they get off? Like, first of all, is there any evidence that she ran over John O'Keefe's foot? No. No. So what's the point of citing this statement from her if she actually said it? What's the point of citing it? Does it match the evidence? It does not, right? And we all know, everyone paying attention to this case, we all know that initially Karen Reed said, "Could I have hit him?" She did not know what happened to her man. She said, "Could I have hit him?" Because she takes responsibility for her actions, unlike the McCabe's and the Alberts and Brian Higgins and the MSP and the Canton PD and the Boston PD. Karen Reed was willing to take responsibility if, in fact, she was the one that did this. She had no idea what happened. Only the McCabe's and the Alberts and Brian Higgins knew what happened. Initially, they were the only ones who knew what happened. All Karen Reed remembered was dropping John O'Keefe off. That's all she remembered. And she saw him go to the door, and then she was back at his house at One Meadows by 12:36 a.m., according to Massachusetts State Trooper Nicholas Guarino. Karen Reed didn't fucking know what happened. In fact, she was livid. She was angry with John O'Keefe because she didn't know what happened to him. She's like, "Where the hell are you at?" You know? For hours, she's calling him and texting him, angry. She did not know what happened to him. And when she saw him, because Jennifer McCabe and uh what was her name? The other chick. Anyway, Carrie Roberts, yeah. Carrie Roberts and Jennifer McCabe brought Karen Reed to John O'Keefe's body. Jennifer McCabe knew where John O'Keefe was. Jennifer McCabe had left that house. She left the house. She knew where John O'Keefe was, and she's the one that made the search. How long to die? So Jennifer McCabe knew where John O'Keefe was. Jennifer McCabe knew what happened. Karen Reed did not know what happened. And that's what we all understand. Those of us who understand the facts of this case, that's what we know about this case. She did not know what happened until she realized Jennifer McCabe was lying, the McCabes and the Alberts were lying, Brian Higgins was lying, and the evidence exonerated her. She found out as time progressed what really happened to John O'Keefe. So this citation from the interview is shit. She's merely repeating what she already said over and over again. Anyway, guys, I'm going to have to make a part 2. Thank you for watching.